Welcome to our Workers' Comp webinar, Part 2, your ultimate destination for navigating the intricate world of workers' compensation. In this Part 2, we dive into the critical aspects of handling workplace injuries, from reporting procedures to understanding the complexities of medical treatment, rehabilitation, and temporary disability benefits. Let's empower ourselves with knowledge on workers' comp in California. Let's dive into our next important subject in the workers' compensation system here in California, and that's reporting an injury. What is the importance behind reporting an injury? How does someone do it? How do you notify them that you've been injured? What does that look like?
So the first step to reporting an injury is filling out what's called a DWC-1 claim form. This is a state form that's used to report all work injuries. You can Google it, or we can drop a link to a copy of it so you guys can check it out. But really, it's just a form that you fill out and your employer fills out, and that gets sent to the insurance company. And that basically starts the formal process of reporting your case. And sometimes it's not so easy to get your hands on one of these forms because maybe you have a really shady employer, or maybe you're in a position where your injury is so catastrophic that you're not conscious or able to actually fill out the form.
Or maybe your business is just not so organized where it's like your boss probably doesn't even know what a DWC-1, which happens small mops and pops places.
Yeah, there's some businesses, maybe they have 2 employees, they've never had a work comp case before, and they don't know what to do. They know they pay work comp insurance, but they're not sure what to do beyond that. So yeah, it's important you fill out the form if you can. If you can't, at least reporting the claim to your supervisor. If you are going to report the claim and not fill out the form because you can't or it's not available, make sure you report it in writing.
Text message will work?
Text message will work. Emails work.
Right.
Even if you didn't put it in writing, but you documented who you spoke to, when you spoke to them, like what number you called, those types of things, the more evidence you have to substantiate that you reported your work injury, the better off you'll be. And the reason why you report the work injury to the employer is because they provide that then to their insurance company. They're legally obligated to do that. So once the claim gets reported to the insurance company, that really starts the process.
Interesting. What happens when you can't get your hands on it? What is the employer's responsibility to kind of come in? And let's say your injury took you straight into the hospital or you were knocked out unconscious. What is the responsibility of your employer?
So the employer is not forgiven for just, taking the ostrich approach and sticking their head in the sand and hoping that, if you didn't tell them and you didn't fill out a claim form, that they can just, walk away from it with no issues, right? They have an obligation if they knew or should have known of the work injury from any source, which means if you're working with a colleague and the colleague watches you fall off a roof, you break your neck, you get carted off to the hospital, and your colleague calls your supervisor and says, hey, tell the home office that, Bob fell off the roof, he's gone to the hospital. That's good enough to start the process. The employer then has to report that claim to the insurance company, even if you did not directly report it. So they have a duty to actually exercise good judgment. And if they have reason to know about the injury, they need to report it to the insurance company.
Okay, perfect scenario. It's life. What happens if they don't?
Well, they can be held accountable for insurance fraud, for one. They can be held accountable for what's called a 132A claim, which is discrimination based on having been injured at work and trying to report it. If, for example, they're told by a colleague that you were injured and then they're like, whatever, forget it. They just disregard it. That could be a form of discrimination or retaliation against you. But they can be held legally accountable for that, whether it's penalties, sanctions, insurance fraud, a bunch of other stuff.
Does this also include when the employer tries to bribe an employee and says, hey, just say this happened at work, at home, it didn't happen at work? Does that fall into play as well?
Absolutely. Absolutely. And that's, again, it's probably a form of insurance fraud. And, companies, if they're licensed contractors, can lose their license. They can get into serious trouble for it. But one of the important components to think about, too, is if the employer is that kind of employer where they're going to lie about it, because when people get hurt at work, the employer's insurance can go up. It's like car accidents. The more accidents you're in, the higher your premium is. Same thing for workers' comp insurance. And so employers sometimes don't like workers' comp cases because they look at it as like a personal attack where they say, oh, well, you're causing me to pay more money and you're causing problems, blah, blah, blah. So sometimes employers do try to coax employees into saying that their injury did not happen at the job site because maybe they have a close relationship and they say, oh, well, you don't want to hurt my
This
business,
is
you
my
know.
brother-in-law. Like, I can't do that to my brother-in-law.
Yeah,
That's his business.
or even, you've worked together for a long time and the employer's guilt tripping you, says, "Oh, well, you care about us, you care about our relationship. We've been good to you. You want to be good to us, right?
Right.
If you go to the doctor and say this happened at work, that, it'll cause increased costs and I don't know if I can afford that and blah, blah, blah." And then the employee's like, "Sure, boss, like, I care about you. I care about this business. I'm loyal. I've been here. I will say, I'll go tell my doctor I hurt my back while my friend was moving a couch or something."
Mm-hmm.
Then that gets put into the medical records that you got hurt helping your friend move a couch. And then when you come try and file the claim later because you need back surgery, your employer's like, "I don't know what happened. He didn't get hurt at work. He said he's helping his friend move a couch."
Mm-hmm.
So never listen to your employer. Make sure you always report it in writing, again, if possible, because that can be a big problem later.
How often do you see this scenario play out?
All the time. I'm in the middle of a trial right now where the same exact issue is happening.
Interesting. That's good to know.
Yep.
In a nutshell, just write it, have it in writing, report the injury. Don't try to undermine what happened at work or where it happened. That's kind of like your receipt to starting your workers' compensation claim here in California.
Yeah, and I think it's important to specify when you're talking about imputing knowledge to the employer, make sure you're reporting it to someone in a supervisory capacity, like an agent of the employer that's responsible for overseeing you or other people at the company, someone that's above you. It always helps to have witnesses to your other colleagues and such, but really you want to go straight, as much as you can, straight to the source when you're reporting the case.
Next, we're going to dive into the medical treatment and the rehabilitation. What are your rights to medical treatment? Talk a little bit about what that looks like.
So in workers' compensation, medical treatment is a little bit different than what going to your own private doctor through insurance is like. So when you get hurt and you have insurance, you go to your doctor. Your doctor says, "Hey, I want to give you medical care. I'm going to do X, Y, and Z. Go down to the second floor of the Kaiser building, get an MRI, then go to the first floor and stop at the pharmacy on your way out." And it's like you got everything you needed that day.
Mm-hmm.
In workers' comp, there's a system. Well, there's a couple of different systems. There's one, it's called the medical treatment utilization schedule, which is basically a guide that tells you how to treat injured workers or patients in workers' comp, meaning you do certain things in a certain way, kind of check the boxes along the way. And there's something called utilization review, which is probably the worst thing to ever exist in workers' comp. And really, utilization review is a system in which the insurance company has medical professionals reviewing your doctor's requests for authorization and saying yes or no. So let's say you go to your doctor and your doctor says, "I want to do an MRI." You're like, "Great, I would love an MRI. I think it'd help figure out what's going on with me." And your doctor says, "Great, I'll request authorization for it." Your doctor submits a request for authorization, and then utilization review for the insurance company gets to say, "No, that's not happening," or "Yes, it is."
Okay.
And so your doctor can say they want to do all this different stuff. "I want to give you pain medication, epidural injections, MRI, send you off for chiropractic." And the insurance company can say, "Nope, nope, nope, nope,
Yikes.
nope." Yep. It's a really awful system. So because of that, a lot of injured workers are deprived of the medical care they actually need. There is an appeals process for utilization review denials, and that's called independent medical review. And that's essentially appealing to the state to take a second look to say, "Hey, is the insurance company abusing, their power here, or did this doctor not necessarily review the right material or understand the request in the right way? And should the denial be overturned?"
Right.
And right now, the overturn rate's pretty low. About 90% of utilization review denials are upheld on appeal.
Nice.
No, not nice. Terrible. Terrible, terrible, terrible.
Nice to know that it's not going to work in your benefit.
Yeah.
This is essentially that sucks. So this is, again, obtaining some sort of authorization for medical treatment. It looks like it's a nightmare in the sense of they're not making it easy for you.
No, you don't just go and get treatment like you would with your doctor. Right. I think that's the biggest takeaway. So, when you go to your doctor's appointments, there's setting the expectation that you may have these great conversations with your doctor about the things that they want to do for you, but those things may not actually happen
if they don't get approved. So what does it look like choosing a treating physician? How do you even go about that? Like, I would hate to have a doctor that just is careless.
So there's things in workers' compensation called medical provider networks. Most insurance carriers and employers have them nowadays. Basically, this is a network of doctors that are pre-authorized to see you. They still require authorization, but they're on like the good list, right? Where you're allowed to go see them. The rule in workers' compensation essentially is that if there is a valid medical provider network and you don't have a pre-designated physician or something like that, that you need to go to an in-network doctor. It means you can't go to your primary care doctor that you see, you know, in your own private insurance.
Right.
You're limited. So you have to select a doctor from the network. Sometimes there's a lot of choices. Sometimes there's not many.
Right. So what's essentially the role of this MPN list? Why do they have this rule set in place that you could only choose those specific doctors? How does that play in?
So there's a lot of rules in workers' comp, especially for doctors, as well as lawyers, as well as injured workers and insurance companies. And the rules basically govern how doctors operate. And within the medical provider network, there's doctors that agree to do things in a certain way, right? You have to write reports in a certain way. You have to bill in a certain way. You can't just do whatever you want, whenever you want. So you have to be part of the medical provider network to actually see the first patient or see the patient in the first place. Then you still have to play by the rules and do things the right way after. So, you know, you wind up in a situation where in some respects, I guess it can be helpful because it streamlines the process a little bit, but others it's rather bad because it limits who you can see and when you can see them.
What are some of the tips you can give someone that's going through the system now in regards to choosing an MPN? Is there some sort of trick or some sort of something that they can look at from this NPN list? First of all, does the injured worker even get to see this NPN list? Is the doctor just assigned to you automatically? Like, how does this fall into place?
So when you're first injured at work, insurance companies have medical control. You go to the first appointment with the industrial clinic. Usually it's not a great clinic. Usually it's one that's, you know, designed to get you back to work as soon as possible and not give you the most medical care or benefits. And once you see that doctor, you're entitled to choose a new doctor afterwards. And so the insurance company, upon request, can provide you with a link to the medical provider network.
Right.
And usually it's online. You simply log in and you go to the website and you type in a specialty or geographic radius, and then you basically pick a doctor from the list, and then you designate that doctor as your primary treating physician. And primary treating physician refers to, think of it like the quarterback of your workers' comp case. They're like the main hub for all things medical. If you need, let's say you're seeing an occupational medicine doctor, but you need a spine surgery. The occupational medicine doctor may still be your primary treating physician, but they may request that you see a spine surgery consult, or they may say, you know what, you have depression, stress, and anxiety. You need to go see a psychologist or psychiatrist as well.
Gotcha.
And so they stay on the case as kind of like the hub of everything, and you keep going back to see them. But as you're seeing them, maybe you branch off and see other doctors as well.
Interesting. It's a lot of information to dive into. And again, you're going to be able to find all of the main points that we're going to be talking about in this webinar throughout the rest of the descriptions and stuff. So make sure you guys visit every link we share so that way you get an in-depth conversation or information in regards to some of this stuff. Let's jump into medical treatment and rehabilitation. What is your right to medical treatment? I heard in previous conversations you were having, there's a lot of authorizations happening. Nothing happens without authorization. So essentially, what is your right to medical treatment?
It's whatever utilization review blesses you with and allows you to have. So, you know, generally speaking, if you have a workers' comp case, you're entitled to all medical treatment that's reasonably necessary to cure or relieve, you know, your symptoms. And that, of course, is subject to utilization review, which means as much as doctors may feel you have a need for certain medical care, you may not necessarily actually be entitled to it. But your need for medical care, in theory, could never go away, in which case you could have a situation where you're entitled to medical care for the rest of your life.
What does this look like for someone that has been injured at work? They are now treating for temporary medical treatment or temporary benefits. Let's dive into what this temporary looks like. What is temporary disability?
So temporary disability is a form of benefit that's designed to compensate you for lost wages while you're recovering from your injury. The idea is that you're off of work, you can't earn a paycheck, you should be getting these benefits to kind of help you get by. And it's generally calculated by multiplying your average weekly wage, 2/3 of your average weekly wage is the calculation, up to minimums and maximums in California. So if you make less than a certain amount, you get a bare minimum. If you make more than a certain amount, you don't get any more. There's the maximum.
Yikes.
So yeah, you could be someone who's in a high paid position, but your temporary disability may not necessarily be 2/3 of your average weekly wage because it's too high,
Right.
which happens. But temporary disability, you can be paid generally up to 2 years, up to 5 years from your date of injury. So the payments could be a total of 2 years within that 5-year period. And it can be broken up. You could get it for 6 months, go back to work, then go off again, get it another 6 months and then another year, all within like 3 years, and you're good. If you start your temporary disability at year 4, following your date of injury, you don't get 2 years because it caps out at 5.
Yikes.
So it doesn't matter if you didn't use it or not.
You'll just get the remaining of, if it was 1 year, we started at the 4.
Yep, you just get that one. And there are exceptions to that. I believe HIV, high velocity eye injuries, amputations, those are all injuries generally considered catastrophic. And so the temporary disability extends to 240 weeks.
Interesting.
Instead of 104.
What is the eligibility criteria to get temporary disability?
So there's 2 forms of temporary disability. There's temporary partial disability, which means that you're not bedridden, right? You can still do something. It's just the doctor gave you work restrictions. And because of those work restrictions, the employer can't have you working at all, or may have you working in a limited capacity. And so you're temporarily partially disabled. And so maybe your temporary disability rate is only the difference between working 40 hours versus 20. Or maybe you just can't work at all. You're temporarily partially disabled at one job. Maybe you have a second job that you can still work at, right? So you may be temporarily partially disabled and entitled to TPD because of the wage difference. You can also be temporarily totally disabled, which means like, you're not working. That's it. You get 2/3 of your average weekly wage, and that's that.
Are there any time limits? You mentioned maximum benefits, but are there any time limits assigned to this temporary disability besides the capped weeks that you can get it in the 3 years? Are there any other times for example, if someone didn't report their injury on time, what does that look like?
So there are statute limitations that apply to workers' comp cases. Those are separate issues, but generally speaking, for temporary disability, the other kind of time limitation is once you've reached maximum medical improvement. And that means that the doctor feels as though your condition has medically plateaued so that it doesn't matter what they want to do. If they want to do surgery, if they want to do injections, you just don't get any more benefits, temporary disability benefits, because you've plateaued, and at which point your benefits transition to permanent disability benefits.